So, governance reviews. What are we going to talk about today? We thought that we would start off by talking a little bit about what governance means, because if we're going to be reviewing governance, it's probably helpful to set the scene on that and just try and work out what we mean by governance. And then we're going to go on and try to answer some questions. So why would you carry out a review of governance? How do you carry one out? What are the likely key deliverables? And which areas of focus are likely to be most important? Now, quite a bit of that is necessarily going to be at a reasonably high level, and that's really because different charities are constituted in different ways. They have different legal forms, different governing documents. They also have differing operating requirements, that they may be doing quite different things. And they may also, crucially, we think, have quite different cultures. So it's not a one-size-fits-all type thing, but there are some general principles that we believe will be relevant to the vast majority of charities when they're thinking about reviewing the governance. So what do we mean by governance? I think it's really helpful to start with really the definition of the charity trustee's role, which comes from the Charities Act 2011, which essentially says that the charity's trustees are the people who are responsible for its management and control. That's the legal definition that applies. But there's no single definition of what governance means, but the one that we like is that it's the process of both making and implementing decisions in order to manage and control your charity. So link back to that legal obligation under the Act there. And the reason we like that definition is that we think that in practice, the core of what the trustees of a charity do and need to do is make decisions and make good decisions, because it's those good decisions that will achieve the ultimate aim of enabling a charity to better advance its charitable objects, whatever those are, and to do so in a way which is compliant with all relevant law and regulation. So in our view, there's a very clear connection between good governance and what a charity can actually do at the end of the day in terms of delivering what it's been set up to do. We just wanted to say a little bit about the Charity Commission. We think it's always important to know what the regulator thinks about particular issues. And perhaps surprisingly, there's actually very little specific guidance from the Commission on governance reviews, but the whole concept of good governance runs through most of their regulatory output, including a great deal of their guidance. What they do though, is endorse the Charity Governance Code. And I just wanted to say a little bit about that, because Laura is going to be picking up on aspects of it as we go through. And I'm sure many of you will be aware of the Charity Governance Code, but just in case it's helpful, this is a code created by a steering group, which is made up of people drawn from a wide range of sector bodies, including people like Akivo and the Association of Chairs and NCVO. It's very much a voluntary code. There is no legal or regulatory obligation on a charity to adopt it. The approach it takes is what's described as apply or explain. So it's envisaged that where the code is adopted by a charity, that there will be a report from the trustees and a report which explains essentially those areas of the code that have been applied, and where that hasn't happened, an explanation of why not. Now, the code is designed in two versions for larger and smaller charities. There are no sort of hard lines around what constitutes a large or a small charity, although I think as a working principle, it suggests that a charity with an annual income of over £1 million is likely to be a larger charity. And the requirements of the code differ slightly as between smaller and larger charities. But the common theme is that they're all aimed at, that the code is aimed ultimately at what is described as organizational purpose, which is really the code's way of saying the better delivery of a charity's objects, as I was referring to earlier on. And the building blocks for that, there are various principles around leadership, integrity, decision-making, board effectiveness, which I'm going to come back to in a second, EDI, and openness and accountability. So the code, a useful document, we think. As I said, Laura's going to come back to that. Other things to be aware of in this context, as regards to the Charity Commission, we would suggest that their guidance on decision-making by trustees is a significant piece of guidance in this space. Many of you may be aware of that. We think it's one of the most useful bits of guidance that the Commission produce. In simple terms, it sets out a way in which they expect charity trustees to make decisions, and that's really around ensuring that all relevant information is available, ensuring that trustees have identified all relevant factors and disregard any that are irrelevant. If advice is required, taking it and considering it, and managing conflicts of interest. So that guidance is important. So one of the things we think we can take away from the Commission's perspective is that the kind of good decision making I've just been talking about requires a good governance framework. And from a practical perspective, we're seeing more and more evidence, I guess, over the last 18 to 24 months of the Commission taking quite an evidential basis to trustees' decisions when they're asked to look at it. That might be because the charities trustees are asking the Commission to do something, so make an order or provide some advice, or it may be because the Commission have a regulatory interest in what they consider might be instances of misconduct or mismanagement by trustees. And their approach in those cases we've seen more recently is always to look back at what evidence is available of the decision-making process adopted by the trustees. So every charity will have a governance framework. The scope and complexity of that will depend upon the charity's size and its income, what it does, how many staff it has, the sectors within which it's operating. So again, not a one-size-fits-all, but we think there are three fundamental building blocks within a governance framework, which is probably helpful just to talk about briefly. We think the fundamental building block is the charity's constitution. Now, depending on how that's constituted, we could be talking about articles of association for a company, we could be talking about a trustee, we could be talking about a charity commission scheme, or perhaps just a set of rules. But that document, the constitution, is going to be the bedrock, really, of the governance framework. And again, we'll pick up on that as we go through. Overlying that are what we described as policies and procedures. So again, these are likely to be documents. They are essentially the documents that the trustees consider are required in order to ensure that they are effectively managing and controlling their charities. So we've mentioned a few examples on the slides, but for us, a key one will generally be the scheme of delegation, and we'll come back to that. Perhaps code of conduct for the trustees, terms of reference for committees, but there will be other documents as well, for example, a policy on conflicts of interest. And then the final tier sitting on top of both of those things is what we've called board effectiveness. This is one of the principles under the Charity Governance Code. And I suppose that tier is really to do with how well the trustees do their job. So it's less tangible, but we think equally as important as documents. And if we just think about some of the component parts of board effectiveness, we just pulled out a few points here we think are important. So culture, behaviours, I said at the beginning, in our experience, every charity's culture is slightly different, but that will be an important driving factor in terms of how trustees approach their decision making. The skills and expertise that the board have, the skills and expertise that the board might need but don't have. And that will flow through to things like the programme of work, the frequency of meetings, the expectations around conduct and participation, and how trustees will collaborate together, how they will constructively challenge one another in terms of decisions, picking up on the Commission's guidance, what kind of access they have and need to advice and information, and then fundamentally an awareness of their duties and also of the Constitution and the policies and procedures. So that's all by way of background. I'm going to hand over to Laura now, who's going to talk a bit about why you would carry out a review and get into more detail around how that might happen.
Thank you, Con. So as Con has mentioned, the Charity Commission doesn't have any specific guidance around governance reviews or carrying out governance reviews. But it's very clear that the Commission does consider that it is vital that charities get their heads around governance. And this is all part of trustees ensuring that they are appropriately discharging their duties and responsibilities to the charity. To follow good governance practice is really understanding and implementing and properly applying robust processes. It's not just about having some documents in a cupboard stored on a computer somewhere. It's really about what you do with them in practice. The Commission has said it's about attitudes and culture, whether a charity puts its values into practice. It's about how trustees make decisions, as Con's referred to, and how well they understand what's going on. And the Commission has said that many of the bad headlines in recent years affecting the sector could have been averted if good governance practices had actually been put in place and followed. And I'm sure you'll all be aware of the negative press around, for example, Kids Company and Oxfam, and the wider effect they had on the charity sector. That said, it's not just about avoiding issues. Actually carrying out a governance review could help charities to realise their potential, understand and maximise what your charity does to advance its objects for the public benefit. So there really are various reasons why your charity might be looking at carrying out a governance review. You might just be carrying out a regular planned review. You could make use of the Charity Governance Code, which Con's mentioned. It's worth bearing in mind that the code recommends a board reviews its governance annually, and that every 3 years, in particular larger charities, involve an external expert for the review, and we'll come on to talk about that type of review shortly. The code is designed to support continuous improvement, and so can be very useful for regular reviews, as it allows boards to continuously review and reflect on the code's principles. But other reasons for considering a review might include a change in strategy or operating approach, driven by events arising in the lifetime of your charity, for example, a change in chief executive or a chair of trustees. Or charities may have experienced or be experiencing issues. These might range from an isolated matter, which leads to a wider review, or more significant issues such as a funding crisis or issue which causes significant issues for the charity's reputation. So in terms of scope, this is very much dependent on your charity. But as a starting point, the National Council for Voluntary Organisations has split its reviews into 3 types. So as set out on the slide, self-assessment, streamlined review, or full review. There really are no hard and fast rules around this, but just to give you some pointers as to the different types of review. Self-assessment is the lightest touch review you could carry out. And this type of review is the one that the Charity Governance Code envisages would be carried out annually. Whereas the full review, which we'll come on to talk about, would be carried out less frequently. The general approach here with the self-assessment is that each trustee, and if you have a staff team, your senior managers are involved and they contribute against the same benchmark. You could use the Charity Governance Code's diagnostic tools available on their website, or the NCVO have what they call a governance wheel, which is prepared using the Charity Governance Code as a benchmark. Once you have feedback from all your participants against the benchmarks, then the contributions should be discussed and any actions identified and agreed by the board. The advantage of taking this approach is that it is simple and therefore cost effective and can be quick, depending on how quickly you get your responses back from participants. However, because of the way in which it's carried out, it is very subjective and much less rigorous than the other reviews that we'll come on to talk about. And that's partly because it is not looking at the charity's constitution or any other policies and procedures it has in place. So the streamlined review is the self-assessment plus option. The plus in this case could be a review of policies and procedures, interviews with trustees, observing how the board functions as a group, carrying out an audit of board minutes. Again, as with the self-assessment, the board would discuss the findings of the review and identify and agree any actions. Again, this approach is relatively straightforward and cost-effective and can be quick, although will take longer than the self-assessment, because it's more in-depth looking at policies and procedures. Again, it's subjective and less rigorous than the full review. So on the full review, this is everything we've identified under the self-assessment and streamlined review approach. But here you'd also be looking at your charity's constitution, if you have subcommittees of the board, their terms of reference, the terms of delegation to your staff team. You'd also be looking at carrying out a skills audit of your board, and perhaps also looking at diversity and inclusivity on the board, and looking at your staff roles and staffing structure. This approach is more rigorous and, in our experience, is likely to include an external reviewer. This brings with it the key advantage of it having a more objective perspective. And it's probably worth saying that it may involve an external reviewer, but maybe not for the whole of the review. There might be a specific aspect that you want the external reviewer to be involved in rather than across the whole governance review. The result would be to have a clear set of recommendations and a plan for development, but actually it could result in providing reassurance to the board and the staff team, if you have a staff team in place, that the arrangements you do have in place in governing the charity are working well. The obvious downside to this approach, because of its thorough nature, is that it will take up more resource, and by that we mean time and also cost of getting an external reviewer in. There does also need to be more commitment from those involved, purely because of the time and the cost, just to ensure that carrying out this thorough approach is justified and that there will be value to be derived from it. In terms of key considerations, again, just to emphasise, this is going to be different depending on your charity, but I think it's a given that you need to be really clear on the objectives and outcomes. Why are you doing the review and what do you want to get out of it at the end of the day? This will dictate the scope and the deliverables. You can also decide whether you adopt a standard approach to the review. So as we've talked about, the Charity Governance Code or the NCVO tool, this may be sufficient for many charities, but it's worth bearing in mind that for those charities operating in a further regulated sector, so for example the housing sector, then it may be that there are other standards of governance that you need to be benchmarking yourself against. Depending on why you're carrying out the review will dictate the timetable. If it's a proactive review, then it's possible that you've got more time to carry out the review, whereas if you're reacting to an issue that's arisen, then it may be that the timetable is set by that. You may also have internal deadlines. For example, if you're setting a budget or you need to recruit more staff. From our experience, we think having a working group in place really helps to drive forward the review. And if ultimately all staff and trustees may be involved, but having that working group really helps to keep focus and to drive the timetable. Also, if there are particularly specialist subjects being considered as part of the review, then if you have anybody on the board or on the staff team who has that particular expertise, then really worth bearing them in mind for the working group. If you appoint an external reviewer, so you're doing a full review, then it's very likely that they will have their own approach that they want to take, but still having the working group could be a real support to that person reviewing. If the trustees and staff team understand the reason for the review, in our experience, it's more likely that they'll be cooperative and supportive. And we really would say that being transparent, open and honest really helps to take everyone on the same journey. You might also want to consider, as part of carrying out the review, involving other of your charity stakeholders. So, for example, In the context of membership charities, then your members, if you have a volunteer body, service users and funders, their perspective on how the charity is governed can be really key. But if you do involve other stakeholders, it's really worth bearing in mind how you might think about feeding back to them. And that's all part of discharging your duty of accountability.
Thank you, Laura. I'm going to spend a little bit of time talking now about the kind of areas, important areas we see coming up in governance reviews. And I'd say that's both in our experience as lawyers, but also actually Laura and I are both trustees as well, and have been involved in governance reviews. So we hope we have a trustee's perspective as well. So what I'm going to talk about is not an exhaustive list, but in our experience, they tend to be the kind of things that can occupy quite a lot of time and attention and focus. So I just wanted to talk a little bit about some of those. The first one to talk about really is the charity's objects. And in our experience, this can often form part of a governance review. There may be a number of reasons why a charity wishes to change its objects, which of course will be in its constitution. Those could range from a sense that they don't reflect the kind of modern terminology, modern society, just in the way that they're phrased, so that actually their focus is not changing fundamentally in legal terms, but actually they could be expressed in a better, perhaps more accessible way, and in a way which speaks to the charity's stakeholders more effectively. At the other extreme, it may be that a part of the review is to make sure that the objects do actually cover the full range of activities that a charity is carrying out. And we do see a reasonable number of cases where a charity has developed its services over time without necessarily updating its objects. So there can be a mismatch between what the charity is doing on the ground as a result of a change in the context within which it's operating, or a change in strategy, where that's not reflected in the objects. And it's obviously important from both a charity law and actually potentially a tax perspective that is the case. If you are thinking about changing your objects, then that is something that's going to require the consent of the Charity Commission, which can take some time to obtain. So that's something that, obviously, just thinking back to what Laura was saying about having a plan around your timetable, would definitely need to be factored in. And the same is true of certain other aspects of the Constitution, should you wish to consider changing those. So, for example, if you wanted to extend or modernise the range of benefits which are available to trustees, then that's again something that the Commission will need to consent to. The composition of the board is also, in our experience, something that often requires a lot of attention. It depends a bit on the existing arrangements that you have for the appointment of trustees. In some cases, that may just be that it is the trustees themselves who appoint their successors. So it's essentially a self-perpetuating body. Some might call it a sort of oligarchical structure. So the trustees are ultimately in control of their own composition. But we often see other examples where, for example, third parties have the ability to nominate trustees to a board. And perhaps if you're a charity with a membership, the members have a right to appoint some or all of the trustees at a general meeting. Sometimes, in some cases, we see a mix of all of those three things. And that's obviously significant because if good governance depends upon good decision-making, then one really important point is that obviously any charity's board needs to have trustees with the correct mix of skills and experience on the board. And we've certainly seen examples of situations where one of the things that is under review is whether and how the Board of Trustees should have some control over that, where, for example, there are rights vested in third parties or the members to appoint trustees. What say should the trustees themselves have about who is actually appointed? Because if they have specific gaps in their skill and expertise matrix, and that again might be something else that's identified via a review, then what say should they have in the individuals who are actually appointed? One other key area of focus that we see coming up in practice is the question of terms of office for trustees. We still see a surprisingly large number of charities where actually trustees are appointed without any limit on the amount of time for which they can serve. We also see examples of, particularly where we're looking at charitable companies, of trustee appointment provisions which depend upon the charity having an AGM, which it turns out actually never happens in practice. So again, one ends up with a lack of clarity and trustees staying in office over a long period. Now, in principle, there is no objection to that. If someone sets up a charity and decides that they don't want to set term limits for trustees, then they're able to do that. I think our view would be that the direction of travel we've seen in the sector is that actually, particularly as part of governance reviews, many boards would be looking at implementing a fixed term for trustees and a fixed number of terms for trustees. And that supports the ability to ensure that there is the correct mix of skills and experience on the board, so that new people can be brought on over time. Often a governance review can be the opportunity to kind of reset the composition of the board as well. There's certainly the capacity to, if you're adopting a new approach to terms of office for the trustees, to have a reset at that point. Linked to terms of office, another thing that we see coming out is around the removal of trustees. Again, we see many charities where there is no ability for the board of trustees to remove one of their number if they have concerns about, for example, that individual trustee's conduct outside the charity, which may have a reputational impact on the charity itself. That might perhaps be because they are active on social media and they post things which the board do not want their charity to be associated with. And that's something that's obviously under focus from the Commission at the moment, given their recent guidance on the use of social media by charities. So that specific point is often something that comes up in the context of a review of the Constitution as part of a governance review. But it links in a way, we think, to a wider question about trustee conduct and what expectations does a board wish to set about the way in which they expect trustees to behave. So that's not just about not posting inappropriate things on social media, it's also about more positive things. So setting an expectation at the outset around, for example, the degree of participation that's expected by trustees, that attendance at meetings is expected, that attendance at meetings having read the papers is expected. So we think that kind of code of conduct is something that ought to be considered as part of a fuller governance review. As I've said, it sets expectations, not just for the board, but we think careful thought needs to be given as part of any governance review to what you're going to end up in terms of inducting new trustees, and not just inducting them, but attracting new trustees, because trustees can be hard to find. So attracting new trustees and then inducting them really, really effectively. So a code of conduct, we think, can be an important document and something that if you have it, you'd want to review it. If you don't, you might identify it as a gap in your policies and procedures. And linked to that, we would also generally be looking at something around what happens if there is a breach of that code. So what are the implications? So conflicts of interest, trustee benefits, you'll all be well aware, I'm sure, that trustees have an obligation to act on a voluntary basis. They also have a duty to declare and avoid conflicts of interest. This is one of those areas that requires a strong framework within the Constitution, but will also typically require strong policies around the management of conflicts, clarity around where trustees can benefit, the basis on which that's going to happen. So again, as part of a fuller governance review, we would generally expect trustees to be looking at the constitutional arrangements around conflicts, but also a conflict of interest policy, and a policy potentially on certainly trustees' expenses, but could also extend trustee remuneration. And those are obviously typically areas of interest to the Charity Commission from a regulatory basis. So it's important to have those in mind. Now, those are going to be important policies. One thing you might want to think about in terms of policies more generally, for those of you who've recently had to complete or been involved with the completion of a Charity Commission annual return, you'll know that they've recently changed their approach there, and that as part of the annual return, one has to tick various boxes to say which policies are actually in place within a charity. And I think we'd suggest that, again, if you're carrying out a fuller governance review, that might be a useful resource to think about in terms of, okay, are we covering all the bases here in terms of the way that we make decisions, the way in which we control and manage the charity. Wanted to say a little bit about delegation and assurance, and again, without telling you all things you're already aware of, delegation for us is certainly at the heart of the way in which most charities which have staff and have a sort of higher degree of complexity will operate, while the actual legal obligation on trustees is to discharge their duties personally. They have, and of course need, the ability to delegate their powers to others. Could be committees of the board, will typically be senior leadership team. And that's a really, really important thing for trustees to be able to do, but really also important to appreciate that where powers are delegated, the trustees are not delegating responsibility for the exercise of those powers, so that where a delegation happens, there is an ongoing obligation on the board to ensure that they maintain the correct degree of oversight over the way in which the delegates are acting and discharging the delegated powers, and that they're receiving an appropriate degree of assurance that that's actually happening in practice. So for us, another key document that's going to be the focus of a fuller governance review is going to be a scheme of delegation, I suppose is what it would generally be called. It may be called something else, but essentially it will set out in detail the basis on which the board have decided they will delegate their powers to committees and to the senior leadership team. And they will typically sit alongside terms of reference for committees, and typically either terms of reference for senior leaders or perhaps appropriate job descriptions in their employment contracts. And putting all of those documents together is typically going to be very important. Most charities will have them. If they don't and there's a gap, then again, that may form part of an assessment of or within a fuller governance review. Linked to that is the question of risk identification, management and assurance. So again, there is some helpful guidance from the Charity Commission around that. It's called CC26. I won't talk about it in detail, but given the obligation on trustees when they're managing and controlling their charity to identify risk and to manage those risks appropriately, that's clearly going to be a theme, we think, that will run through most fuller reviews of governance, because again, it's down to the trustees to ensure that they have the correct degree of assurance that the things they think need to be done in order to manage risk within the charity are actually happening. And then finally, there will of course be a whole range of what we've called on the slide charity-specific issues. So things that will be relevant to governance and may well form part of a governance review, which are driven really by what the charity actually does in practice. So I've mentioned on the slide a few examples of that. Of course, the Commission's approach to safeguarding is that a charity has to safeguard the interests of all of the people it comes into contact with, but there will be certain charities, those involved with, for example, children, vulnerable adults, where of course safeguarding will be an absolutely key risk issue. Many charities may have investments, some won't. Clearly, where charities do have investments, then a policy is going to be required. And the same will be true, again, depending on the operating context and a range of other issues, including things like health and safety and data protection. So I hope that's been a helpful talk through what we think are some of the key areas within a governance review. I'm just going to hand back to Laura now just to talk about a few potentially complicating factors.
So these are some complicating factors that we've come across in our experience of charities going out for governance reviews. Of course, they may not be relevant to your particular structures, but in case they are relevant. Membership charities. So these are charities with a separate group of either individuals or organisational members, and they might have rights under the charities constitution and also possibly the law or just the law. So, for example, in a charitable company, there is a requirement under company law for a company to have members, and that brings with it certain rights and powers under the company's legislation. So, for example, as part of your governance review, if you identified a change being required to your articles of association, that would require a member's decision. And if you've got a separate membership, that can cause difficulties in getting that decision through. Another area to mention is where charities have subsidiary companies. So these could be charitable or non-charitable subsidiaries. Now, a subsidiary is an asset of the charity, so the charity's trustees have a duty to protect that asset. But obviously bear in mind that because it is a separate entity, it will have its own board of directors, its own decision-making body. And whilst there's likely to be some overlap with the charity's board, there should, from a good governance perspective, also be some independent directors. The Charity Commission's guidance does reference the need for independent directors for one reason, to help in managing conflicts of interest that may arise from time to time between the charity and the subsidiary. But the key point here is because there is a separate decision-making body, then it is to an extent out of the control of the charity, although worth bearing in mind that it is possible in setting up the structure in the first place that some powers have been reserved to the charity itself. In terms of group structures, here we're including federated charities. So with this group of charities, quite often implementing changes can require the approval or consent from a central body. So just to highlight that this could prevent or stall the implementation of any recommendations that are highlighted through your review. And finally, just to pick up on linked charities. So these are charities that are linked by the Charity Commission to a main charity for registration and accounting purposes, or either registration or accounting purposes. And they are linked because of either common trustees or charitable objects, or potentially both. It's worth bearing in mind as part of your review that these linked charities remain separate charities, regardless of how they might appear on the register. And in our experience, particularly where your main reporting charity is the sole trustee of the linked charity, often the case where charities have endowment, then this can give rise to conflicts of interest, which are not that easily managed. Hopefully those are helpful just to flag. And just to end, hopefully some useful links on this slide, linking back to points we've picked up during the session. So the Charity Governance Code, as I've mentioned, the whole code available for smaller and larger charities on there, but also the diagnostic tools that we referenced. They can be downloaded and edited really straightforwardly. Charity Commission guidance, we've specifically mentioned the CC27 decision-making guidance, but all of the Charity Commission's guidance is freely available on its website. Con's mentioned some other pieces of guidance which are useful in this context. And finally, just a link to the NCVO's governance review section of their website.
Thank you, Laura. We'll stop sharing our screen now, and we've got some questions already in the Q&A, so we'll address those, I think. Perhaps the first one we'll talk about is a question. I'll just read this out. So, not-for-profit organisations in sectors such as housing associations and further education, some of which are actually charities, have to abide by our governance code. Do you think this should be the case for some charities, perhaps those over a certain size and or delivering regulated public services? e.g. those in health and social care education. So maybe I'll try and answer that, and Laura, maybe you could chip in. I think it's a really good and interesting question. There certainly are codes that apply to charities that do specific things. I mean, the one I come across in practice quite a lot is the CUC code, which applies to charitable, which applies to universities, the vast majority of which are charities. I think the point of the charity governance code is that is the closest document one would have on a sector-wide basis. And I think the difficulty in trying to have a code which would cover the entire sector and which all trustees would need to abide by comes back really to the diversity of the sector. So, the sheer range of things that charities do in 2023. So I suspect that it would be difficult to have a mandatory code which would apply to all charities, perhaps even just all charities over a certain size. And I suspect that when Akivo and NCVO and the Association of Chairs were thinking about the Charity Governance Code, which was a number of years ago, that was probably one of the driving factors that they had in coming up with the code that we have now, which is a reasonably high level document. It talks about principles fundamentally, with some sort of subsidiary principles under each of those. So, Laura, did you have anything to add?
I don't have anything to add on that one, no.
So the next one is going to be, are you going to discuss cost in carrying out such reviews? Again, maybe, Laura, would you like to comment on that?
Yeah. And thank you for the question. I think it's quite difficult to give a specific response to that question, which I'm sorry is not particularly helpful, because it really depends on the type of review you're doing, and particularly whether you're going to be carrying out the full review, and in doing the full review, whether you are involving an external person. We have worked with people who are reviewers. Equally, we have taken on that role of reviewer, and it does really depend on the scope. But I think what's really key, and as we've talked about, is just identifying what that scope is in the first place, to make sure that the review really is what the charity needs. Because particularly, again, where you do have the external reviewer coming in, you don't want to waste anyone's time or the charity's money in not having that scope pinned down. So I would say, if you're going to get an external person in, part of the very initial stages will be just getting that scope right, and then when you get it's easier then for the external reviewer to then provide you with an idea of their costs for that.
Thank you, Laura. I think the only thing I'd add is, this may be slightly contentious, it's really just to pick up on what Laura said, which is the scope of what you ask an external reviewer to do is really important. So we quite often see those when a charity will come to us and say, can you help us implement the recommended changes that we've concluded are necessary? And it's quite interesting. Often you'll see a review which actually is really, really helpful. So it will include, for example, really clear feedback on where trustees themselves and senior leaders see the issues. And I think that kind of process is really invaluable and cost and worth the money. I think sometimes we've seen examples of things that actually, being honest, perhaps might really only tell trustees things they already knew. Now, that doesn't necessarily mean you don't need an external reviewer to confirm that, but I think it does come back to being very clear about the scope of what you ask them to do. Next question, can you give us a steer on whom one could approach to carry out number 2 and number 3 of the types of reviews? So that would be the streamline review and the full review. And there are a number of organisations out there that do provide that kind of service. Sort of sector-wide, there are bodies like the Good Governance Institute and the Institute of Directors. I think NCVO is a good starting point in terms of signposting to people that may be able to help. Depending on the sector that you're in, There may also be very specific providers. So just picking on, for example, education, that there are organisations like RS Academics, Cairneagle and Judicium who all carry out governance reviews. I hope that's helpful. Next question, is there a specific guidance about linked charities that you can point me to? Laura?
Yes, so on the Charity Commission public facing website, there is some guidance on why you would link charities, how you do it, and what the outcome of that is if the linking is successful. The Charity Commission also do publish its called operational guidance. It's the Charity Commission's sort of internal guidance for their case officers, but as I said, it is also publicly available. And if you were just to put in a search engine Charity Commission operational guidance, then you'll get the index of that. There's also a detailed publication on linked charities, so I would have a look at those.
That's all right. Next question, what are the boundaries for the charity trustees in relation to oversight and micromanagement in terms of effective and constructive challenge? So yes, that's an interesting question. That comes back for me to the point I was making about delegation. So trustees delegating their powers, but not responsibility for the exercise of those powers. I tend to think that it sometimes helps to think about a graph when you're thinking about the relationship between the trustees and the senior leadership team. And on one axis you have what I'm going to call trust, and at the other axis you have what I call challenge. And I think the key thing for charity trustees in this space is working out for them what is the correct balance between that trust and that challenge. So at one extreme, you might have a board who are essentially supine. They have complete trust in senior leaders. They don't challenge on anything. And by challenge, I really mean they don't seek assurance, for example, that powers are being exercised in the way they anticipate. At the other extreme, you can have a board which is really very, very challenging, and this is where you stray into the territory of the kind of micromanagement that you've talked about, which obviously defeats the purpose in many ways of employing an expert and professional senior leadership team to exercise those delegated powers. So again, I think there's no single answer to this. It's for every board to work out what they think works best in terms of giving senior leaders the authority they need to act, but also ensuring that at the same time the trustees retain the correct degree of oversight and assurance. Next question. How effective do you think is the Charity Commission in dealing with charities where there's clear evidence of misconduct, not necessarily financial mismanagement? Do they intervene often enough, or do they intervene too much? Laura, do you want to try and answer that?
Yeah, it's a good question, and I think possibly quite a subjective answer, and possibly Con's not even going to agree with what I say, but my view from my experience of working with the Commission is that generally the Commission is effective in dealing with charities. They are a risk-based regulator and they have a limited amount of capacity and resource, so we do see that coming through. Another thing I would say, particularly in my experience, is that the approach by the Charity Commission and the effectiveness is sometimes driven by the case officer that you get. I think the more experienced case officers can, and I guess this is a given with their experience, they can be ultimately more proactive and helpful. I think that there was a time where the Charity Commission were more amenable to talking about things, either on the telephone or having a meeting. I think a lot of their correspondence and general communication is in writing now by email, and I don't always find that that's necessarily helpful in having an effective outcome. I mean, I don't know whether you want to comment, but we certainly do have cases where we've almost asked the Charity Commission to take some kind of action and they've been unwilling to do it, which isn't always helpful.
I think that's true. I think one of the things to bear in mind the Commission is when they exercise their regulatory powers of intervention, there's generally the capacity that they will get challenged on that in the charity tribunal. which is not a tribunal where anyone can recover their costs. And given the Commission have limited resource, I think our sense sometimes is that they will go quite a long way to avoid having to make a decision which is potentially reviewable within the charity tribunal. Now, I'm speculating slightly, and that may be a little unfair, but I think as an organisation with limited resource, one could understand why they are sometimes cautious about taking that kind of regulatory action. So, do they intervene often enough, or do they intervene too much? I'm afraid to say I'm not sure there is a clear answer to that. I suspect that there are charities out there kind of floating under the radar, not aware of serious incident reporting, if they are not making a report where the Commission ought to be aware and ought to be taking action. Next question. Charities that are typically well governed often engage in reviews. However, charities where governance needs improvement can be resistant to reviews. Are there ways to encourage, even force reviews other than what the Constitution provides? Again, another excellent question. We certainly see that in practice. As you said, it's often the best run charities that are very aware they need to be staying on top of and reviewing their governance. Sometimes one can have quite a resistant trustee body. Certainly seen examples where senior leaders are very clear that change is required and that a review is the right way to deal with that. And the short answer to your question, is there a way to force the board if they're resistant? The short answer is no. There's no obvious way of doing that other than, I think, potentially trying to take the board on a journey. And the way I've seen that done often is to provide them with perhaps more information about their role, about their duties, about the risks, about where those risks might lead the charity. And obviously, although we've already talked about perhaps the Commission's reluctance to get involved as regulator, they do get involved, and there are some really good examples of where they have got involved. And so perhaps it's trying to take the board on that journey and helping them to understand why it might be important to think about changing the way they're governed. Anything to add, Laura?
Well, no, I think the unfortunate reality is that sometimes it takes something to go wrong for those charities that are not proactive in reviewing governance for them to actually look at it. And it is difficult when you've got maybe one or two trustees who are very proactive in that kind of thing, trying to turn the board. But I think if you are one of those people, then definitely worth plugging away, and as Con said, gradually trying to explain why it's really important to keep reviewing this kind of thing.
Final question: do you have a template for best practice scheme of delegation? Well, we don't have a one-size-fits-all template. We do have various examples that we use, but it comes back a little bit to, again, the diversity of the sector and the different ways in which charities operate. So we do have examples, but I'm afraid we don't have a one-size-fits-all, because we typically find that actually that's never the case in practice. One has to understand a bit about all of those things around the Constitution and the policies and procedures and the board's culture and board effectiveness. But it's certainly something we can assist with. So I think we are drawing to a close on questions. We really hope that this has been helpful to you. Thank you all very much for taking the time to attend. It's much appreciated. And I think there'll be a poll on feedback. So this is the first time we've delivered this webinar, and so any feedback that you can provide will be very, very helpful to us in terms of future versions of this session. But in the meantime, let you go with 3 minutes to go. It's probably time for a cup of tea or a cup of coffee, and I hope you all have a great day.
Yeah.